Welcome to our YouTube video series on franchise law. My name is Christopher Neufeld, the Neufeld Legal. And in this particular video, we're going to be discussing the importance of reviewing your franchise agreement and disclosure documents, but also recognizing that there's probably going to be a limited ability to make any modification to those agreements. Now, what you really need to understand is the importance of a lawyer is to guide you through the process and to explain to you the responsibilities that are demanded from the franchisor through the franchise agreement and via the disclosure documents that's provided to you. And your expectation should really not be to make substantive changes to those documents other than with respect to aspects of pricing, territory, and other conditions that are negotiable. For the most part, let's say 95% of the agreement is set in stone. And especially with the more established franchise systems, there's going to be no changes that are going to be allowed by the franchisor. If you don't want to accept their agreement, well, you're not going to get a franchise system. And that is how they proceed with their operations. They have one uniform approach, and everything is structured to their benefit. So it's entirely pro-franchisor. As a franchisee, you don't really have much recourse. You're going to have to deal with much of the stuff outside the terms of the franchise agreement, because for the most part, when I look at franchise agreements, there's very little recourse available except for the most disastrous, most heinous acts of the franchisor. And even then, oftentimes, there's really no recourse then too. So you got to understand, when you sign up to a franchise, the franchisor is dictating the terms. They're dictating the arrangement, and you got to abide by them and recognize what your obligations are. And when issues do arise, you have to deal with them immediately. You need to be talking to legal counsel. You got to be talking to the accountants. And you got to make sure that you communicate enough with the franchisor so you stay on top of stuff. And should there be issues, those issues can be addressed. Oftentimes you'll want to talk to the professionals before jumping in and dealing with the franchisor, but you don't want to wait. You don't want to allow problems to get bigger and bigger. It's not worth your while. That's where the serious problems come about. And it also means that you have to understand what your obligations are. And that's an important aspect that you have to be speaking with a lawyer about, so you understand what your responsibilities are, what your limitations are, what your restrictions are, and what happens when certain circumstances arise. And with everything, there's a degree of negotiation that can still come about even after the agreement's signed. I'm not assuring you that your negotiations will succeed, but by dealing with stuff early on, the franchisor is more likely to deal with it positively, because what they're trying to do is they're trying to make sure that you succeed, because when you succeed, they get their cut off the top, and that's important to them. And they don't want to impact the reputation of the franchise system they built. They want to work with you to a degree, but you always have to understand where your place is, and you always have to be trying to protect yourself. But protecting yourself doesn't mean having the expectation that you're going to rewrite the whole franchise agreement and disclosure document. That is not going to happen. Very much like financing agreements, commercial leasing agreements, the party that's providing it is going to set the terms, and those terms are set out in stone. And they're not going to change it because their lawyers tell them not to change it, and they've constantly expanded, and they've created more and more protections with every clause almost intended to provide an additional protection, because some franchisee in the past has dealt a problem for another franchisor, and every franchisor then gets around to making changes. So whereas you have the statutes that are designed originally 25 years ago or so to protect the franchisees, the big corporate lawyers who represent the franchisors have taken advantage of that legislation, the Franchise Acts, and they've used it to further insulate themselves. They fulfill the obligations of disclosure. They've communicated what needs to be communicated. They've set the timelines, and they understand the timelines very well. And they've done that, but then after that, they put in their own obligations. Without crossing the line from the legislation, without breaking the law, what they do is they make it very much pro-franchisor. Everything is written in favor of the franchisor, and you have to recognize that. You have to accept that, and you have to move forward with that. If you're not prepared to do that, you may as well not even sign up for the franchise system, because almost every franchisor out there is going to take the same hardball approach and demand that you sign off on their agreement, and that is the end of it. Especially for the big ones. They can't have 150 different franchise agreements floating around there. One consistent practice, everybody operates under it, and that's the end of the story. You have to understand what your obligations are, your responsibilities, your restrictions, and so on and so forth. You have to know what they are. You got to keep on top of them. And when issues do arise, like I say, you need to talk to professionals, and you can't let it wait. You need to deal with it. But that's what you're dealing with, a franchise agreement and disclosure documents. You're dealing with something that, yes, you should get it reviewed. Yes, you should get it explained to you. But don't expect to make substantive changes to it. You might have some corrections due, few and far between. These are templated documents, and you have to recognize that, appreciate that, and move forward on that basis. Thank you.